Hi, my name is Wendy Hillmuth. I'm one of the attorneys here at Unsworth Plans, and I'm here to provide some clarity on myths and misconceptions regarding estate planning. So the first myth we're going to talk about is that estate planning is only for the wealthy. It's simply not true. Estate planning is for everyone. Everyone would benefit from having a plan in place, but especially it's important for the young families who maybe want to have documents that outline guardians and provisions for their minor children. It's important for college students who might need to appoint financial agents or healthcare agents. It's very important for individuals or couples who want to avoid probate court in the future. They might want to protect their assets and make sure that their estate is distributed as they wish. It's also important for individuals who need to plan for long-term care. Myth number 2, the next misconception we're going to talk about is that a last will avoids probate. This is simply not true. Having a last will and testament does not avoid probate. What happens is that the will is actually instructions to a probate judge as to how you would like your estate distributed. And it does not avoid probate. And in fact, you will incur several court fees, there might be publishing fees, or all sorts of other types of fees if you have your will go through probate. Any assets that are in your name at your death that can only be distributed by a judge, even if you have a will. In order to avoid this, the trust would help. Facts about probate. Probate can be expensive. There are court fees, publication and bond fees, executors and attorney's fees. It's a time-consuming process. Probate proceedings can take up to a year to settle or even more. And it's open to the public. It is not a private matter. All the information that is filed with the court is on the public record. Notices have to be given to creditors too. So that means publication in the newspaper or some type of news journal. And that makes your estate out there for everyone to see. Myth number 3, estate planning is only about distributing assets. That is simply not true. There are several benefits to having an estate. You can have power of attorney agents nominated, healthcare directives, which name an agent to make medical decisions for you. You can protect your assets and help plan for long-term care needs, become incapacitated. Again, young families can need guardians and have outlines of what they would like those guardians to do with their children in the future if they were to die. You can control how your estate is distributed on minimizing taxes, protecting your beneficiaries, and minimizing disputes amongst family members. You can also provide end-of-life wishes. Once an estate plan is created, it cannot be changed. This is a myth we hear often from people, and it's simply not true. When you have an estate plan, if it's a revocable living trust, you can modify it at any time. And there are ways to modify certain provisions of other estate plan documents as well. You should always update your estate planning documents if you have any changes to your marriage, if there's a divorce, if there's a birth of a child or a grandchild, if there's a change in your financial situation, if new assets or you sell major assets, you'd like to revise some of your agents named in your documents. These are reasons to update or modify your estate plan. And by keeping your estate plan current, you provide peace of mind that your intentions will be honored at your death, and your loved ones will be adequately cared for. The next myth we're going to explore is joint ownership avoids probate. We hear this all the time in our practice. People think that if they add someone's name to an asset, they're actually protecting themselves. But in fact, that is actually a problem. Joint ownership might seem like a straightforward approach, but it comes with several setbacks and risks. One is lack of flexibility. If you have someone else on an asset with you, you have limited control. You handed over some of that control. And if you don't agree on things, there's going to be conflict. The state and gift tax implications will appear as well if you add other people to the title of your assets. And there are always the risk of creditors. If a person that you add onto a title, one of your assets, has liability exposure or lawsuits, whatever it is, divorce complications, those are suddenly going to be your problem too. The next myth we're going to explore is estate planning is too expensive or complicated. That is simply not true. At Unsworth the Plan, we guide you through each step, making it as straightforward and easy to understand as possible. We also like to think that we are very accessible to ask questions and to continue the discussions that you might want to continue after your estate plan is signed. The cost of an estate plan is actually far less than the potential expenses that you might have if you own something probate court or if you have a claim that doesn't work. Thank you so much.